Good morning, Detective. Why don't you step up there for me? And if you could raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, sir. Go ahead and have a seat.
My name is Kyle Harmon, Kylehharon.
Mr. Santos.
Thank you, Your Honor. Good morning.
Good morning.
Detective Harmon, can you tell the jury how you're currently employed?
I'm currently employed with the Denver Police Department.
Okay, and are you with a specific unit at the Denver Police Department?
I am with the Sex Crimes Unit.
All right, and what is your role within the Sex Crimes Unit?
I'm a detective.
All right, how long have you been a detective with the Sex Crimes Unit?
I'm a little over 4 years now.
All right.
Christelle Nicholas walked into the District 2 substation and made a counter report with the officer there. That officer completed a report, and which was sent to my unit. And then, as I said, our supervisors review all of those reports, and then that particular case was assigned to me.
November 4th is when you receive all these labs back, correct?
Correct.
All right, and so I just want to kind of recap the timing here. So this happens August 5th, or between the August 4th and 5th of 2023.
Correct.
You get assigned August 7th.
Correct.
By the time all the lab testing and all the other stuff is done, it is November of 2024, the next year, correct?
That's correct.
All right.
May 15th, 2024, you got the DNA lab results back, correct?
Correct.
You reviewed the results that day, correct?
Correct.
Did you ever call and confront Ms. Nichols about the DNA results and give her an option to explain or change her story?
No.
Do you know if Ms. Nichols, based on your investigation, ever knows what the lab results are?
I believe I spoke with her and told her a general idea of what the lab results were.
At one point, you suggested you had a fear that it could be somebody else who broke into the house, correct?
As I was accepting the reality of the assault, that was likely one of the train of thoughts that came before the actualization that the person assaulting me was Frank.
Right, you had a lot of train of thoughts you talked about. You said this can't be real. It has to be somebody else who broke into the house, correct? You said, am I dreaming? Is this a dream? It was a lot of denial. Do I wake up? Do I catch him? Do I confront him? Do I scream? If this is somebody that I knew, then clearly I don't know them. And if it's somebody I don't know, then I don't know how they're going to take it. Like, once I put together that it was him, I guess I don't know if he was further capable, and that scared me into not confronting him. Those are the thoughts that went through your mind, correct?
Correct.
And there may even have been sex assaults where he came in and you didn't hear the creak, correct?
It could have. I was not conscious at the time, so I cannot state whether it did or did not happen.
You also talked earlier, a minute ago, about the DNA. Did you ever get a call from Detective Harmon to talk about what the DNA found or didn't find?
There was email correspondence between Detective Harmon and myself.
Really? How many email communications were there on this?
Between 10? No, around 10. Again, those emails I have saved, so the actual images of them would be more accurate, and I'm happy to provide them.
Did anybody ever ask you to provide them?
I don't recall, I guess not.
Okay. To the best of your knowledge, you've never given them to anybody other than Detective Harmon, correct?
Well, it was Detective Harmon I was corresponding to, and I would also forward these, or I would tell Maureen to keep her updated with what was happening.
May we approach for a moment? You're saying that all the communication you had with Detective Harmon as it relates to what was found in the DNA or not found or who was found is in those, bless you, is in those emails?
I recall the email of there was a match for Frank's DNA and the evidence in the scene kit. The one prior to that was male DNA was found. I asked, what does that mean? I saw the email where it was a match, and my first knee-jerk response was like, oh my God, it's not for nothing that I have something. And then within that, because with all this time, even though I know I experienced the assault. I had such a wish and desire that it didn't happen, that it didn't uproot my life. After the joy, it turned to a different emotion because it confirmed to me that it did happen and it wasn't something that I dreamed. Like, this is the reality.
So testifying under oath today, you believe, based on your phone calls and emails with Detective Harmon, they found his DNA?
Yes.
Did he tell you about the other person's DNA?
I know that there was male DNA found, and then the email stating that there has been a match with Frank. I don't know about any other DNA.
Oh my gosh, it wasn't just a dream. So the reason she believes, and in full disclosure, she believes it's a match for Frank, there's nobody else's DNA, I was proven right, based upon phone calls and emails with this detective. We know there's a DNA issue and the court has the DNA reports. We know that's just simply not true. And I apologize, but that goes beyond, gee, I don't understand DNA as a detective. He's lying to her intentionally. And it's in either a phone call that he didn't record, or it's in an email that she claims she has, that he's, quote, denying to the best of his knowledge at this time of having those emails. We have a discovery violation because we have communications about the DNA, including false representations by the detective. One of them's lying. Either she had multiple phone calls, as she's testified, and multiple emails, whether it's on a single string or not, and he's lying. Or she's just making it up. She never had these emails, and she's never had these multiple phone calls. The detective's telling the truth. But one of them needs to be impeached. So I know there's a discovery violation, and I know someone's not telling the truth. I don't know who it is, but we have a problem.
So, Your Honor, as I said, I had an investigator come over. The investigator, myself, Wharton, both defense counsel went in and reviewed. There were, in fact, emails between Detective Harmon and Christelle. I think that there are a couple of emails that are of specific concern to defense, and which I understand.
It would have been something used to cross-examination with, because he's not exactly being honest with her, and I think that is a problem.
All right, we're back on the record in 24 CR 6949, People versus Frank Ortiz. All counsel are present. Mr. Ortiz is present. The jury has been excused for the evening. While we were off record, I was provided with a copy of the email referenced previously from Mr. Santos and the detective's response, and then I believe what appears to be 4 sets of email strings between Ms. Nicholas and Detective.
What is really important here is to bring up that this is not a situation where it is some technological failure of the detective where he had tried to send these documents to the prosecution, and then through nobody's actual willful conduct did they then become made aware to the defense, because that would be a threshold discovery violation. It wouldn't be anyone's fault, and it'd still be a discovery violation. What's really important here is that the moment that the prosecution asked for them, they reached out indicating to the detective, hey, these emails, a bunch of them are being mentioned by somebody on the stand. Do you have them? And very immediately, this detective responded, I do not recall any emails. I don't think I did. And I don't have any at this time. This response by Detective Harmon, the idea that he was so confident, so quick, and that he had searched for them, to not find a single thing, and then to say that to the prosecution, indicates directly to the prosecution that whether he did that search and didn't want to share it,
whether he just didn't do that search at all, is a serious issue. Because had this witness not have them, if she had not kept them or if she had hidden this, then this would be the type of conduct we would have never learned of. He had these communications for years. And I don't know the reason he did it, and I don't think it particularly matters. He was saying that he didn't, and I just don't think there's an excuse for it that's pervasive. It makes me question how often that type of thing has happened, and it's the type of discovery violation that warrants a motion to dismiss. So I guess I would ask the court for permission for leave so that I could do a little bit additional research before I respond to the motion to dismiss.
I'm wondering if it makes sense to try and get Detective Harmon here tomorrow morning.
I told Detective Harmon to be here at 8:30.
Okay.
So he will be here at 8:30. I want to just start by asking a couple questions about some things that were sent to you and your responses from yesterday, okay? Sure. So do you recall being sent an email yesterday regarding emails between you and Mr. Nicholas?
Yes.
And do you recall that being sent by the district attorney's office?
Yes.
And that it was a reference to an order from the court, correct?
Correct.
So that was around, I believe, we're looking at, that is 2:26 p.m. Does that sound about right?
That sounds correct.
Okay, so when did you get that? What was your immediate follow-up to that? What did you do?
I think I responded quickly with my recollection that I didn't recall there being many, if any, emails to my recollection at the time, and that I didn't believe, or that I no longer had them based on our retention period for our email.
Okay, so I'm going to kind of slow that down a little bit. So you responded back at 2:31 p.m., right?
Sounds correct.
And if at any point you don't recall what was exactly said, just let me know. I have your emails here. I can refresh your memory, all right?
Perfect.
So what actions did you do before responding when you received this email to go find them?
I don't recall being asked to go find them.
So you just testified under oath that you didn't believe that you were asked to go look for them and provide them?
As the email says, to provide those emails. My understanding was that to provide them, and I responded that I no longer had them.
So you just testified under oath, before I refreshed your memory, that you had said something about a server issue. Did you say that in that immediate email response at 2:31 p.m.?
The reasoning behind, no, I didn't put the reasoning behind my answer in the email.
You don't mention anything about a server at 2:31 p.m., correct?
No.
When you sent that email back, you simply state you don't think you sent any.
No, I think what I sent back was I don't recall there being emails between the two of us, or I don't recall there being a bunch of emails between the two of us, and that I did not have the emails. I believe that's what I sent back.
So you do not have the emails. That's kind of how you ended it, right?
In that email, that's correct.
To you, does that indicate that you would have looked?
No.
To you, I do not have any emails from /to Chriselle in my email at this time. So you mentioned just there a minute ago that, later on in the day, you really wanted to make sure, right? Make sure they weren't there.
Correct.
But you didn't care about that when you responded at 2:31 p.m. yesterday.
I wouldn't agree with that characterization.
Okay. At some point you check, right?
Correct.
When was that?
I don't recall a specific time, but it was later in the afternoon.
After 4 or after 5?
I don't recall. I would have to look.
How soon before you sent the email to the DA's office indicating you found them, how soon before that email did you look and find them?
It was quite quite quick. Like I said, I don't recall.
So your testimony is that you found them, you knew there was a court order to provide them, and you let us proceed for 2.5 hours.
Correct.
Okay. And in fact, that would mean that when you responded at 4:06 p.m., okay, I can be there at 8:30 if needed, you had already found these emails.
I believe that's correct.
And I don't want to belabor this point any further, but you had multiple emails and a phone call after saying you did not have these emails, and you made no effort to correct it, to correct what you had told them until 5:40 p.m.
That was my understanding of when it could be corrected.
I'm sorry, what do you mean that was your understanding of when it could be corrected?
So, like I said, when I sent the email in response to the email asking for the emails, the email was sent with some urgency, and so I responded as quickly as I could with my understanding at the time. And when I later found out that that was incorrect, and I wanted to make sure that I corrected myself at the earliest convenience, I sent that over to the district attorney's office.
Final one on this issue, at least, your earliest convenience, you sent 4 other emails and a phone call, right?
Correct.
And you didn't share it then?
Correct.
Your original statement that you don't even recall emailing Ms. Nicholas at all.
Correct.
It's your testimony under oath that you don't remember emailing Ms. Nicholas at all.
That was my recollection at the time, yeah.
You've now looked to your email.
Correct.
How many emails was it? More than 10.
Probably.
Would you like to review it?
Like I said, I didn't count them yesterday, but sure.
Okay. I mean, you didn't review them, so you don't even know what's in these emails?
I briefly looked over them, but I didn't count every single email.
Did you look to see what the content of them was?
Yes.
Okay, so you looked enough to know that it's more than 10, right?
Correct.
Okay, and that these aren't all just a update email. They are not stock emails, all of them, right?
I mean, we don't have stock emails, but correct.
So they also occur over the course of about 1.5 years, right?
Over the course of the investigation, correct.
So I'm having you look at page 6 of Court Exhibit 4 at the bottom of page 6. Do you see what you had sent to Ms. Nicholas?
Yes.
This was when, or around when, you had received the initial DNA report based on the seine kit and the underwear that was collected, right?
That's correct.
Because at this time, you did not have a warrant for Mr. Ortiz's DNA.
That's correct.
So what do you inform her?
I said, thanks for following up. Do you mind if I read it directly?
I'm fine with that.
I do have some positive updates for you. I've received the DNA lab report, and it indicates that male DNA was located on the inside of the underwear you submitted for testing. Samples from your seine kit were listed as, quote, inconclusive, but additional testing can be completed once I get a DNA sample from Mr. Ortiz.
Having looked at that now, having reviewed it, the last sentence that you mentioned is, if you want to go over these results in detail, give me a call.
Correct.
Did you have that call?
I don't recall. I would have to refer to what's in evidence.com.
So did you ever have a phone call with Ms. Nicholas regarding the DNA?
I'm not sure.
Do you remember testifying yesterday morning about how you believe you did inform her over phone call?
Correct.
Okay, so again, you're under oath, and that was just yesterday. Did you have that phone call or not?
So, like I said, I believe that I had informed her of the DNA results, and believing that, not recalling any emails, I believed they would have been over the phone. Obviously, it was over email.
Do Do you remember having that call?
No.
Okay. And yesterday you still testified under oath that you did. But eventually in November of 2024, you do receive some sort of lab results, DNA results, right?
I believe so.
On that page 9 of Court Exhibit 6, what's the date that the email was sent? I think the date you may have to go to 8 to see it.
It appears to be November 7th, 2024, if I'm reading that correctly.
Okay. And specifically, you state that you received the DNA report and that there was male-specific DNA testing for Frank's DNA profile. Is that fair?
That's correct.
Okay. And you then say, without belaboring the scientific jargon used by the labs, Frank's DNA was found on your external genitalia swabs.
Correct.
In that Court Exhibit 4 email that was from May of 2024, you also referenced male DNA found on her underwear, right?
Correct.
But you don't reference it here.
Correct.
But you did review that report, right?
Yes, I believe we did.
And in that report, there was male DNA, as you had told her in May of 2024.
Correct.
But that now in November of 2024, you found out that Ms. Ortiz was excluded.
From the samples from her underwear. Correct.
And you did not inform her of that.
No.
Now, you also say that Frank's DNA was found.
Correct.
You've been doing this a while, right?
Correct.
What did that report actually say?
It said that there's moderate support for inclusion, which is a ratio term that the lab utilizes.
Good memory. Did you review that before today?
In preparation for yesterday, yeah.
Okay, so it was in preparation for yesterday.
Correct.
All right. And so moderate support for inclusion, right?
Correct.
You don't tell her anything about that, right?
Not in the email.
Maybe on the phone?
No, I apologize. That was, again, if you have any questions, feel free to give me a call. I can certainly expand on that.
Do you remember if there was a call?
No, I don't believe there was.
Okay. So did you ever inform her of the difference between moderate support and the finding of DNA?
No.
Again, you've been in this division specifically, you understand that there's a sometimes misunderstanding of DNA that the layperson has, right?
Correct.
But you have a much better understanding, don't you?
Correct.
And you know that when you say somebody's DNA was found there, that's not what the lab report said.
Like I said, the lab uses a ratio verbiage and essentially, and like I said, not a forensic scientist, but a moderate support for inclusion would indicate that his DNA matched the profile that they found with a moderate support for inclusion.
Okay, and you keep using the word match, but are you, again, I know you're not an expert in this.
Again, my words, not the labs. My understanding from my training with the lab is that when they are able to overlay DNA profiles and find commonalities between DNA profiles, again, in general verbiage, a match, they provide a ratio.
The male DNA that was found in her underwear that wasn't Mr. Ortiz. How'd you react when you found out it wasn't Mr. Ortiz?
I object to relevance at this point.
What's your response?
Your Honor, I believe this is incredibly relevant. This is the type of information that was being shared to the named victim that gave her the impression that there was nothing else nothing else besides a match that was in there. This is something that he had originally told about male DNA being found in the underwear, and then specifically leaves out the exclusion when responding later, giving her the impression.
No, I know that, but what's the response to the relevance as to the discovery violation or?
Well, I think this is into the discovery violation and the violation of the court's order, Your Honor. Seems like there might have been, in our opinion, I think there's an argument, there's a reason that initially these weren't looked for or provided.
Okay,
I think it's relevant to that.
overruled.
Okay. So, when you found out that Ms. Ortiz was excluded from that DNA on the underwear, did you tell anybody about that in this case?
No,
Like any witness?
no,
Did you ever think it was relevant to your investigation or anything that you communicated with her to determine where or whom that match would have been for?
to my recollection, and I think this may have occurred during our in-person interview. And again, I would have to look at the interview again, but this is my recollection, was that I had asked her if there were any other men who may have touched her clothing, anything like that, anything that she had knowledge of, to potentially address that issue. And my recollection of her answer to that was that she did not have any knowledge of anybody else as to why that would be there. So when that lab report came back, my understanding was already that she didn't know why there would be a different profile there, if there was.
You very quickly after that provided the case to the district attorney's office, right?
Correct.
Was it the day you sent that email that's on page 9 of Court's Exhibit 6 that you provided the information to the DA's office?
I would have to look at my supplemental of what day that was.
Is it fair to say that you send an email to her about what charges they're likely to go forward with in Court's Exhibit 6?
No, so this email indicate, I'm sorry, on page 9, this email indicates that I had previously sent the case to the district attorney's office, and they had already tentatively accepted the case for those 3 counts.
Okay. So at that time, you believed that the DA's office was going to accept this case?
They had already provided a tentative acceptance, correct?
So you were sending that email knowing that,
Correct.
and yet you didn't provide any of these emails to them?
Correct.
I have nothing further this time, Your Honor.
Okay, thank you, Detective.
Thank you, Your Honor.
Any additional witnesses?
Not from defense, Your Honor. Intentional misrepresentations that only become something we can even argue when somebody gets caught red-handed with them. And despite the fact that he got caught in this situation, it appears he doubled down to make additional misrepresentations. And then he got on the stand here today and he attempted to do it again. I don't think there's any reason to believe that his testimony about the order in which he received these is honestly truthful, Your Honor, because he's still trying to say that he misunderstood whether there was a court order. He's still testifying under oath that in his original response at 2:31 p.m. that he meant to indicate that there was this belief of this server retention issue. His words under oath do not match those that are sent in this email. They're not close and they cannot coexist.
The issue before me is whether there is a Rule 16 violation, and if there is a Rule 16 violation, what an appropriate remedy would be. When I was looking at the cases that were given to me by the parties yesterday, the circumstance here are statements made by a witness in this case, Ms. Nicholas, to and from another witness in this case, Detective Harmon. These are statements between witnesses. They are written statements, but I think, and everyone seems to agree, I think everyone agrees, really the concerning part is that the detective, when he gets the results and notifies her that the results have been received in both the circumstances, he then conveys to her his interpretation, I suppose, of the DNA results, the analysis and the results. In the first email, that was just the development of the profile or the existence of male DNA regarding the swabs taken during the SANE exam. Again, not fully articulating the results, but advises Ms. Nicholas that partially what they are, at least partially what his interpretation of them are. And then after he gets the results from the comparison analysis, really in many ways misleads her as to the nature of those results. He specifically excluded the fact that Mr. Ortiz was excluded as a contributor in the very sample which he had previously advised her had been tested, but instead misstates and misleads Ms. Nicholas by asserting that they are in effect a match to Mr. Ortiz. A rudimentary reading of the DNA analysis as to the genital swabs would lead no one to believe that they, as the detective states to her, that Frank's DNA was found on her external genitalia swabs. You can't read that conclusion that's in the actual report and in any way interpret that to be what he described in the email to Ms. Nicholas. And then I think as he was saying here today, describing it potentially as a match to Mr. Ortiz. So that's problematic in and of itself. But really what's problematic too is now that we know, well, everyone knew while this was going on that Ms. Nicholas had made statements contained in discovery and at various periods of time as to her uncertainty about who did this and whether it happened. I've heard through testimony that there were previous statements she made about, did this really happen? Was it a dream? Was it him? I mean, she was saying this apparently all along. And then what I heard her testify to yesterday was that when she received what we now know to be that email that's contained in Exhibit 6, where the detective tells her that Frank's DNA was found, I think her testimony was something to the effect of, that's when I knew for sure, or that's when I realized that it was true. What I got from that is her testimony and certainty as to what she testified this jury about was heavily, if not, well, very heavily influenced by the misstatement that the detective made to her about the significance of the DNA interpretation. When I'm trying to figure out what is an appropriate remedy, the remedy has to go to her testimony before this jury and the certainty of it, because it was influenced based on incorrect information that the detective gave to her that nobody knew about until apparently yesterday. To clarify and succinct, court finds a Rule 16 violation. These communications and statements were and discoverable. Again, talking about the materiality, that's not really a consideration right now, but as I've indicated, the crux of the issue is that by providing incorrect DNA results information to Ms. Nichols here, which then solidified her belief in some uncertainty about things that happen, that certainly would qualify as material that would tend to negate it's favorable evidence, it's exculpatory evidence because it goes directly to the certainty of her testimony and how she testified and indeed did testify during the proceedings. The question before me, again, is what is the appropriate remedy? I've already articulated my findings that I don't believe that this was intentional. Withholding, the parties have the emails now. Ultimately, we're going to say I'm not going to grant the motion to dismiss. I think that that is far too severe a sanction given the totality. The fact that we have the emails, Ms. Nicholas is still available for cross-examination.
Your Honor, I understand the court's rule, respectfully. I don't think we can, first off, I don't think Frank's getting a fair trial.
Yes.
And I don't think, with all due respect, saying, gee willikers, they broke the law, which may have misled her, but here we are, and consider, that's not going to fix it. We have to have a mistrial, at the very least. And I say that because part of it is what that detective said. I know the court's going to say that was not intentional. Right? And the fact that he says at 3 o'clock, I knew about it, then was communicating and emailing, and I didn't tell anybody. That's the court's ruling. But that's something the jury, a jury, would need to hear. And they would need to hear about him misleading, and they would need to know about his training and experience. And fully, I don't believe this whole server issue, respectfully, may be true, but I'm going to flush that out in the next trial because I do not believe that's true. And you can't fix it with... We're good though, right? And also, it's vouching for her credibility because the whole premise is the way it played out. It played out in a trial of there are no emails by the detective. He thought it was a phone call. She gets up and says, no, it was emails. I'm certain of it. There was more than one. And then in his last email, when we got the DNA results, he told me to call him and I did. And then we approached and we said, we'll deal with it later. The jury saw it in real time. Now we're going to magically produce emails, which shows she was telling the truth, which bolsters her credibility and also creates sympathy for this person who, one, was, I think the court's use of the term very liberally was misled. She was misled and she's been in therapy for 2 years because of what this detective did and said to him. And as a reward for not turning it over, it's bolstering her credibility. You can't fix that. And not with this jury pool or this jury panel.
I find there's good cause based on defense argument, and I'll grant the motion for mistrial.